Hello, and welcome to Bridging the Gap Across Transition, a training module that will provide you with information on the Americans with Disabilities Act, the ADA, to help you as you attempt to navigate your way from the school system to the world of work or to post-secondary education or training, otherwise known as the transition process. Let's look here at a brief overview on what we will cover in this module. First and foremost, it's very important to know and understand your rights as an individual with a disability under the ADA. The next topic is disclosure, one that is vital to the transition process. We will discuss the who, what, when, how, and why of disclosure. And last but certainly not least, we'll briefly discuss some common accommodation ideas that might be helpful. Let's look here at the differences between the IDEA, or the Individuals with Disabilities Education Act, and the ADA, the Americans with Disabilities Act. The IDEA is a law that protects you as a student with a disability while you're in the school system. It is called an entitlement because if you have a disability, you're automatically covered and provided a free, appropriate public education. You receive special education services, supports, and accommodations. A team of people, including a special education teacher and possibly a speech and language pathologist, an occupational or physical therapist, or other support personnel, meet at least once a year to make plans to ensure that you're making progress and have the accommodations or modifications you need in the classroom. Once you graduate from the school system, you're no longer covered by the IDEA, but rather the ADA, or the Americans with Disabilities Act. It differs from IDEA in several ways. Now you have to qualify as a person with a disability, and the qualification standards have changed. To meet this definition of disability under the ADA, you have to have a physical or mental impairment that substantially limits one or more major life activities, have a record of such an impairment, or be regarded by others as having an impairment. We'll talk about this in more detail in just a few slides. Once you exit the school system and enter post-secondary training or employment, the only way you will receive accommodations is if you ask for them yourself. You may be required to disclose your disability in order to receive the accommodations. You will need to become your own advocate. Self-advocacy simply means that you need to know and speak up for yourself. You have to know your strengths and weaknesses, how you learn, and what you will need to help you succeed. You will need to be comfortable talking about yourself and possibly your disability to prospective employers or to educational professionals. You also need to understand your rights and responsibilities under the ADA. Since we talked briefly about how the ADA differs from IDEA and how the qualification standards have changed, let's look here at the definition of a disability. An individual has a disability under the ADA if he or she has a physical or mental impairment that substantially limits one or more major life activities. Substantially limits means that you are more limited than the average person, and major life activities include but aren't limited to caring for yourself, seeing, hearing, walking, learning, reading, and communicating, and also includes the operation of a major bodily function such as the digestive, circulatory, musculoskeletal, or reproductive functions. An individual also has a disability under the ADA if he or she has a record of such an impairment, for example, an individual with a history of cancer or mental health impairment, or if the individual is regarded by others as having an impairment and is discriminated against in some way for that reason, such as an individual with a facial scar or one rumored to have HIV who weren't hired for those reasons. You may be required to provide medical documentation in order to prove that you do have a disability. Information submitted to an employer should include your diagnosed impairment or medical condition and the major life activity that is substantially limited by the impairment. Remember from a few slides back, those major life activities include but aren't limited to caring for yourself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. Major bodily functions, such as those of the immune system, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions, as well as normal cell growth. Disclosure is when you give out specific personal information about your disability. Deciding whether to disclose a disability can be a difficult decision. Individuals with disabilities sometimes struggle not only with wanting to be honest and open from the start of the job-seeking process, but also with knowing what might happen if they disclose too soon. If and when you do decide to disclose your disability, it will be important to provide the following information: the nature of your disability, the limitations or how the disability affects your capacity to learn and/or perform the job effectively, and the accommodations you will need in order to do the job. Let's look here at the advantages of disclosing your disability. To receive reasonable accommodations, to receive other benefits of employment, to explain an unusual circumstance, provide legal protection, develop self-advocacy skills, reduce stress and increase comfort level, and provide freedom to examine benefits. Now let's look at the disadvantages of disclosure. It's a good idea to seriously consider what results your disclosure may produce. You may be excluded or treated differently. You may be overlooked for a job, a team, or a group. It may be difficult and embarrassing. It may bring up conflicting feelings about yourself, and it may lead to reliving bad past experiences. The 411 on Disability Disclosure, a workbook for youth with disabilities, is designed for youth and adults working with them to learn about disability disclosure. This workbook helps young people make informed decisions about whether or not to disclose their disability and understand how that decision may impact their education, employment, and social lives. Based on the premise that disclosure is a very personal decision, this workbook can help you think about and practice disclosing your disability. The workbook does not tell you what to do. Rather, it helps you make informed decisions about disclosing your disability and how those decisions may affect your education, employment, and social life. When do you disclose? Anytime that you need an accommodation or a change in the way things are done in the workplace. You never have to disclose a disability until you need an accommodation. Under the ADA, you're not required to disclose to an employer at any specific time. The only warning we would give is not to wait too long if there are performance or conduct issues that are directly related to your disability. You can disclose during the application or interview process. An example would be to access an online application system or if you need accommodations for pre-employment testing. At any point during employment, when an accommodation is needed, maybe if the disability changes or when the job tasks have changed. To receive benefits and privileges of employment, for example, here might be access to training, a company cafe, or an employer-sponsored summer picnic that is available to all employees. Or to explain an unusual circumstance. An example here might be absences from work and the inability to call in at the specified time to report the absence. Now let's talk a little bit about how to disclose. The individual must let the employer know an adjustment or change at work is needed for a reason related to a medical condition. To request accommodation, an individual may use plain English, need not mention the ADA, and need not use the phrase reasonable accommodation. It can be as easy as telling your employer, I have difficulty getting to work on time because of the medications I take for a medical condition. Could we talk about that? Now, who do you disclose to? Under the ADA, an individual may disclose a disability and ask for an accommodation either verbally or in writing. At JAN, we recommend that you do so in writing so that you have documentation that you did indeed disclose and ask for an accommodation, and when you did so. We have a sample letter located on our website that can help you with that. Who do you disclose to? The employer, a supervisor or manager, and or a human resources representative can all be persons an employee would make their disclosure to. Oftentimes, an employee doesn't want their supervisor or manager to know about their medical condition. In that case, it is wise to disclose to someone in HR. In many cases, a manager or supervisor may need to be informed of the process and be involved in the accommodations, but wouldn't need information on the medical condition. There may be other specific persons that you would disclose to. Those persons or offices could be determined from the accommodation policy. And if you are a student, the Student Disability Services Office would be a good place to start. You may be required to provide medical documentation for a disability when the disability is not obvious, when the impairment or disability you have isn't visible, such as a learning disability, attention deficit disorder, or a brain injury, or when the need for accommodation is not obvious. If documentation is required, it should include your diagnosed impairment and also the major life activity substantially limited by the impairment. Remember when we talked about those major life activities just a few slides back? The limitations or major life activities are really more important than the diagnosis when it comes to determining accommodations, so be sure to include complete information. Let's look at two examples. If you have a learning disability that causes you particular difficulty with writing, then it would be vital to include information about how your writing ability is affected. Another example is an individual with a brain injury who may have difficulty concentrating and remembering new information. The documentation about concentration and memory would be very helpful in determining accommodations. More broad information about a brain injury in general will not be as useful. Who is an appropriate medical professional? Depending on the disability, there may be different medical professionals that would document the impairment. Medical doctors for specific medical conditions such as diabetes, heart problems, or a back or leg impairment, to name just a few. Specialists in the mental health field such as psychiatrists and psychologists, nurses, physical or occupational therapists for physical or motor impairments. For speech, language, and communication issues, a speech therapist may be the appropriate professional. Vocational rehabilitation professionals are those who may do assessments and evaluations and could verify that you do have a disability. Licensed mental health professionals such as therapists or counselors who may spend time with you and may be able to recommend effective accommodations. And educational professionals are ideal if a learning disability is present or for other impairments such as autism or intellectual disabilities. Now let's look at the different types of accommodations that may be helpful to an individual with a disability. Assistive technology is any item, piece of equipment, software, or product system that is used to increase, maintain, or improve the functional capabilities of individuals with disabilities. That can include products such as apps, speech-to-text software, or can be as simple as colored folders or paper clips. Some examples of modifying a work schedule may include adjusting starting and ending times of the workday, combining regularly scheduled breaks to create one extended break, or dividing large breaks into smaller segments, and allowing work to be completed during hours when the employee is most mentally alert. Acquiring a service could include a job coach, an interpreter, a reader or scribe, as well as a personal attendant or an assistant. Using leave or time off can be an effective accommodation for an individual who needs time off to attend medical appointments related to an episodic or chronic medical impairment such as diabetes, bipolar disorder, or asthma, to obtain medical treatment like chemotherapy, physical therapy, surgery, mental health counseling, inpatient substance abuse treatment, or dialysis, or to recuperate from an illness or surgery, an exacerbation of symptoms associated with an episodic or chronic medical impairment. Several examples of that would be flare-ups of symptoms associated with multiple sclerosis, an intestinal disorder, epilepsy, a back condition, or major depressive disorder. Receiving a reassignment is usually considered an accommodation of last resort that is provided when an individual can no longer do the essential functions of his current position and no accommodations have been found to be effective in that position. Other accommodations include telework or working from home. In a position where that is possible may be a very effective accommodation. Even if an employer has no formal telework policy, they should consider providing that as an accommodation, even on a temporary or trial basis. Adjusting supervisory method under the ADA, the employer is not required to provide a new supervisor. However, they would be required to consider changing a supervisory method. That could include providing written instruction and requiring less face-to-face interaction. Using a service animal may be considered an accommodation the same as any other accommodation is considered by the employer. Modifying a policy for someone with a disability could include allowing a flexible start time, modifying an attendance policy, or allowing an employee to bring a service animal when the employer has a no animals policy. Changing a policy doesn't mean that the employer has to do so for all employees. You can reach us here at JAN by calling toll-free at 800-526-7234 for voice or 877-781-9403 for TTY, or visit us on the web at askjan.org. You can also contact us through text and Skype and find us on Twitter, Facebook, LinkedIn, and other social networks. We also have a live chat feature that has become very popular. This concludes our presentation on the transition process. We hope you found it helpful. If you need more information on the ADA or accommodations, please feel free to contact us at JAN. We hope to talk to you soon. Thank you for making JAN a part of your training program. Funding for this training module was provided through the U.S. Department of Labor's Office of Disability Employment Policy.